Well, when we take in a case, we always assume that during the course of a recovery effort to realize upon your judgment, we assume the debtor will file for bankruptcy. And we always do an assessment of your case from that context. A bankruptcy will sidetrack our recovery effort for up to 18 months, typically. What we do in that circumstance, we want to know if we can file what's called an adversary action. That's a separate lawsuit inside the bankruptcy, asking the bankruptcy court to bar the debtor from either receiving a discharge of debt of any kind or from discharging just your debt and letting him discharge everyone else in the world. And there are various reasons for doing one, the other, or both. We always make it very clear that a debtor may need to file for bankruptcy. There are times I'll sit the debtor down and say, you really do need to file for bankruptcy, but you can't afford to do it until you take care of us and wait 90 days plus a day. Because if you don't do it that way, we're going to keep you from discharging any of your debt. And there are other times we'll say, go ahead and file bankruptcy. We'll file our adversary and we'll just bar you from discharging our debt, and we'll pick up the trail again in 18 months on the other side and start learning what machinations and mischief you've been up to in the interim to gather assets from other people. So we always make this assessment on the front end of the case, and we always want to assess the quality of the facts of our case with respect to the ability to prevail in that adversary action. Because if you just don't have the facts that give us a really solid opportunity of prevailing there, then the likelihood of our securing a recovery diminishes greatly. And we want you to know that on the front end. The other aspect of this, we assess how long it's been since the debtor filed his or her its last bankruptcy. An individual debtor can only do this once every 7 years.